Good day, madam and everyone. My name is Alex Tang Felix Itom. Today, our group will present the topic Examine the application of the jurisdictional fact doctrine. For my part, I will briefly explain the meaning of the doctrine, its practical application, and its doctrinal foundation. Let us begin with the introduction. The jurisdictional fact doctrine is an important principle in Malaysian administrative law. In simple terms, it means that an administrative authority must first have certain essential or threshold facts before it can be legally exercise its statutory power. These facts are known as jurisdictional facts. If the required fact does not actually exist, the authority cannot legally exercise that power. If the authority wrongly assumes that the condition exists, its decision may be ultra vires, meaning it is beyond the authority given by law. The court may then review and quash the unlawful decision through certiorari. The doctrine is also connected with Article 4, Clause 1 of the Federal Constitution, which support the principle of constitutional supremacy. Therefore, an administrative authority cannot simply create jurisdiction for itself by making an incorrect finding about a factual requirement. Moving to the practical application, the court may need to determine whether the required jurisdictional fact actually existed. This is different from the usual Wetness-Bury standard of review. Under Wetness-Bury, the court mainly consider matters such as legality, rationality, and procedural propriety. For the jurisdictional fact, the focus is on whether the required fact objectively existed. However, there is an important difficulty. The court must distinguish between a jurisdictional fact which determine whether the authority has power to act and the fact within jurisdiction which the decision maker is authorized by statutes to determine. When the legislation is unclear, the court may need to consider the purpose and context of the statute. This creates a balance between controlling administrative power and avoiding excessive judicial intervention. Finally, the doctrine has a preventive purpose. An administrative authority must first establish the objective fact that give it legal authority to act. The doctrine prevents the authority from assuming jurisdiction based on an incorrect factual finding. It also helps to control arbitrary and unfiltered administrative discretion and protect the rule of law. In Malaysia, this principle operates within the judicial review framework under Order 53 of the Rule of Court 2012. So in the simple term, the jurisdiction fact doctrine acts as a legal protection against an authority going beyond the limit of its statutory power. That is all from me. Thank you, madam and everyone.
Assalamualaikum and hi everyone. My part is the analysis on the application of the jurisdictional fact doctrine in Malaysia. Jurisdictional fact doctrine means before an administrative body can exercise its power, certain facts must objectively exist. If the fact does not exist, the decision is void and the court can review. Based on our slide, we will analyze how this doctrine is applied when faced with four main challenges in Malaysia. First is structural complexity. In Malaysia, we have a dual legal framework. One is secular civil courts and two is Sharia courts. Actually, this creates a jurisdictional fact problem. For the Sharia court to act, one jurisdictional fact must exist. The person must be a Muslim. But because of decentralization, each state defines and proves this differently. As Muhammad Yusuf and Ali say, there is no uniform method nationwide. So the court must first determine this jurisdictional fact before it can hear the case. If it gets it wrong, the whole decision can challenge under judicial review. Second is judicial balancing in determining jurisdictional facts. When courts decide if a jurisdictional fact exists, they face tension between textual rigidity and maslahah. What is textual rigidity and maslahah? Textual rigidity means they must strictly follow the evidence required by law, and maslahah means they may interpret for public goods. As Abdul Rahim and Omar said, this balancing affects how strictly the court will review if the fact truly exists. Third is procedural and evidentiary challenges in proving jurisdictional. It is very hard to prove jurisdictional fact in three areas actually. First is cyberspace in digital enforcement. Two is burden of proof and certainty. Three is gazetted fatwas. For the cyberspace and digital enforcement, how do you prove a offense happened online? Cypherids and others say our digital framework is underdeveloped. No evidence means no jurisdiction. Second is burden of proof and certainty. In FASA cases, who bears the burden to prove the jurisdictional fact of harm or neglect? This ambiguity makes it hard for the court to confirm jurisdiction. Third is gazetted fatwas. If a fatwa is the jurisdictional fact for an offense, but procedures are inconsistent across states, Mustafa and others say then it becomes unclear if the fact is valid for the court to act. Lastly is reform trajectories to improve application of the doctrine. We got ADR mediation and comparative regional studies. What is ADR? ADR is alternative dispute resolution. This can help bypass rigid fights over jurisdictional facts, but it is also hindered by inconsistent state laws, so parties still end up in court arguing over jurisdiction. Second is comparative regional studies. We can learn from other countries. According to Abraham and Kusmaiti and Rahman, countries like Indonesia have better models for coordination between central and state authorities. Better coordination means clearer rules on what counts as a jurisdictional fact, so there is less dispute and better access to administrative justice.
This is our first case, Wong Chi Hong and Cathay Organization. This case is about Section 20 of the Industrial Relations Act 1967. In this case, the employer said the worker resigned, not was dismissed. The court decided that a dismissal must generally exist as a fact before the industrial court can use its power. If there was no dismissal, the industrial court has no jurisdiction at all. It cannot create its own power just by wrongly believing a dismissal happens. So the key lesson from this case is simple. A tribunal cannot invent its own foundation. The jurisdictional fact was really exist first. Our second case is Muhammad Azam bin Muhammad Noor and Ketua Polis Negara in year 2002. The case involved Section 73(1) of the Internal Security Act 1960, together with Article 5(1) of the Federal Constitution, which protects a person's right to liberty. Because before this case, courts were often willing to simply trust the executive opinion. We just accept what the official says, but the federal court changed this. The court says that because this case involves a fundamental right, liberty, the reason to believe cannot just be a private subjective belief. It must be an objective legal test. The police must show real objective evidence to the court. If they cannot show the evidence, then the arrest and detention were unlawful from the very start. So this case shows a shift from blindly trusting subjective belief to demanding an objective, probable reality. Our third case is Syarikat Kenderaan Melayu Kelantan Berhad and Transport Workers Union 1995. In this case, Parliament tried to stop the courts from reviewing certain decisions completely. This case involves Section 33(b)(1) of the Industrial Relations Act 1967. This section is called an ouster clause. An ouster clause says that decisions of the industrial court are final and cannot be challenged in the High Court. The Court of Appeal, through the judgment of Gopal Sri Ram, clarified that if a tribunal makes an error about a threshold statutory condition, a jurisdictional fact, then the tribunal has actually gone beyond its power. Its decision becomes an absolutely nullity, meaning it has no legal effect at all, as if it's never happened. And because the decision is a nullity, the ouster clause simply cannot protect it. In summary, Wong Chi Hong dealt with employment law under the Industrial Relations Act. The threshold fact was dismissal. The court used the standard of correctness. The result was that the decision was quashed through a veil of statutorily Muhammad Azam case deal with national security under the Internal Security Act. The threshold fact was reason to believe. Here, the court required objective evidence, not just a subjective feeling. The result was that the detention was found unlawful from the very beginning. And in Syarikat Kenderaan, the case deals with an administrative decision against under the Industrial Relations Act. The threshold fact was a general statutory condition. The court demanded absolute accuracy. The result was that the decision became a nullity strong enough to pierce even a statutory ouster clause. These three cases together prove why the jurisdiction facts doctrine matters so much in Malaysia. It protects ordinary people from administrative bodies that try to give themselves power they were never given. Next, we will move to the discussion of comments will be presented by Haika. Thank you.
Good morning everyone. Today, I will discuss the application of the jurisdictional fact doctrine, particularly its role as a safeguard against executive overreach. The jurisdictional fact doctrine means that an administrative authority must have an actual factual condition or requirement before it can legally exercise its power. In other words, an executive authority cannot simply use its power whenever it wants. The necessary facts must exist before the power can be exercised. Therefore, this doctrine acts as an important buffer against executive overreach. It ensures that government agencies operate within the limits of the regulation that give them their powers. This is also closely connected to the rule of law because administrative authorities must act according to the law and cannot go beyond the power given to them. Next, this slide shows the hierarchy of legal authority. At the highest level is the Federal Constitution, Article 4, establish the supremacy of the Constitution. Below the Constitution are parliamentary statutes which provide specific power to government agencies and authorities. At the lower level are executive agencies and tribunals. This body can only exercise powers that have been legally granted to them. Therefore, an administrative authority cannot create or assume a power that Parliament has not given to it. This principle is important because it prevents administrative bodies from exceeding their legal authority. The third point concerns the role of the reviewing court. Normally, a court reviewing an administrative decision may show some degree of deference to the administrative authority, especially regarding matters within its expertise. However, when the issue concerns a true jurisdictional fact, the court takes a more active role. The court may determine independently whether the necessary factual condition actually existed before the authority exercised its power. Therefore, the court effectively acts as a tribunal de novo in determining the existence of the jurisdictional fact. This protects individuals from unlawful exercise of administrative power and strengthens judicial review. Finally, an important issue is distinguishing between a true jurisdictional fact and a fact within jurisdiction. A true jurisdictional fact is a threshold condition that determines whether the authority has jurisdiction to act at all. For this type of fact, the court can conduct a complete judicial review. If the required fact does not exist, the authority has no jurisdiction and its decision may be considered void ab initio, meaning void from the beginning. In contrast, a fact within jurisdiction concerns the merits or manner in which an already authorized authorities' power in exercise. In such case, the court generally gives greater deference to the administrative authority and may only interfere where the decision is unreasonable. Therefore, the main challenge is applying the jurisdictional fact doctrine is correctly identifying whether the fact is a true jurisdictional fact or merely a fact within jurisdictional. Thank you.
Hello, hi, my name is Dia Sofia, and today I will be talking about the conclusion for the topic that my group is taking on. So, to conclude our presentation, we first come to what we call the subjectivity trap, especially in post-hoc judicial determination. As shown here, courts may use contextual and purposeful interpretation to determine legislative intent after an administrative decision has already been made. The difficulty is deciding when an administrative error is serious enough to justify judicial intervention. Because this determination can be subjective, executive bodies may become uncertain about which factual decisions will receive judicial deference and which will undergo complete judicial review. So the result can be administrative instability. So we're moving on to the next slide. I will be talking about the complications of Malaysian legal pluralism. So the issue here becomes even more complicated because of Malaysia's legal pluralism. Our legal system involves federal law, state law, and both civil and Sharia systems. Malaysia's unique combination of legal pluralism, federalism, and linguistic diversity can make the application of the doctrine more difficult. The coexistence of civil and Sharia courts together with different state laws can also create friction, especially when there are questions about jurisdiction or which law should be applied. So the legal structure itself can make judicial review more complex. Moving on to the next slide, which is the structural harmonization. Because of these complications, the doctrine requires structural harmonization to function effectively. There are several systematic friction points, which is overlapping subject matter, such as Islamic family law, banking, and issues involving minors that can lead to jurisdictional disputes and inconsistent judgments. The second point is the federal discrepancies, including differences between state laws, may cause procedural delays. There are also evidentiary complexities, especially in emerging areas like cyberspace enforcement, as well as linguistic diversity, which may affect how factual thresholds are determined. So, better coordination between these different parts of the legal system is really necessary. So moving on to the last slide, which will be talking about the dangers of extreme interpretations. So basically, we need to avoid the dangers of extreme interpretations because on one side, excessive interpretation can cause judicial review to become a merit review, where judges may effectively become primary fact finders. This can lead to the micromanagement of statutory agencies and administrative paralysis. On the other side, excessive differences may fail to enforce proper legal boundaries and allow discretionary power to go unchecked. This may result in abuse of executive discretion and even violations of constitutionally protected rights. So the overall conclusion is that the doctrine requires balance. The court must provide enough review to control serious administrative errors, but not so much that they take over the role of administrative authorities. So that will be the last point for my part. I will like to conclude our presentation by saying thank you and goodbye.